I'm gonna share with you guys. This is one of the documents that that was deleted, right? From it was deleted from my backup, and I'll show you why they decided to delete this. This was my response to. I filed what's called a collateral attack. It's a motion to vacate. You attack an older unconstitutional order that violated constitutional protections. It's supposed to overturn everything that transpired from that. Well, Kevin Siebert, who's illiterate, he didn't read any of it because he doesn't understand it anyways. In fact, when Cassandra brought it to his attention that it was a collateral attack, he's like, huh? So I'm going to go ahead. In fact, it was kind of funny because the clerk of the court didn't even know how to file it. She thought it was a typo. So I had to add this letter in here to send it back to her so that she knew how to file it. Okay, so I'm going to read this letter. I know the address is wrong. I put the old court address in there, but on accident. But here's the letter I sent to the clerk of the court. Dear clerk of the court, I'm writing to provide clarification regarding the legal concept that may be unfamiliar to the court, specifically a collateral attack. During recent proceedings, it became apparent that this term was not widely recognized, as evidenced by District Attorney Cassandra needing to further investigate its meaning and explain it to those present in the courtroom, one, including Judge Siebert. A collateral attack is a legal strategy used to challenge the validity of a previous court ruling in a separate proceeding. Unlike a direct appeal, which is filed within the same case, a collateral attack is initiated independently and seeks to invalidate the original judgment on grounds such as lack of jurisdiction or violation of due process, which, yes, they did not have grounds. In the context in my case, the motion I intended to file is designed to encompass all relevant case numbers that are subject to this collateral attack. Specifically, this motion aims to challenge and vacate the emergency protection order, temporary restraining order, 5-year restraining order, effectively nullifying the associated case number. Additionally, the motion seeks to vacate the contempt charges that arose from these restraining orders, which are linked to 2 criminal cases. This legal maneuver is intended to address and rectify the procedural and substantive issues that have impacted these cases. By vacating the orders and the related contempt charges, the motion aims to remove the district attorney and Clint Parrish from further involvement, thereby resolving both the civil and criminal matter at hand. I trust this explanation provides a clear understanding of the collateral attack and its intended application in my case. Should the court require further information or clarification, I am more than willing to provide additional details or documentation as needed. Thank you for your attention to this matter. I appreciate the court's consideration and look forward to the resolution that upholds the principles of justice and due process. Obviously, they don't. They don't uphold any of that shit. Please feel free to contact me at your earliest convenience should you require any further information or clarification regarding this request. The motion is intended to have multiple case numbers involved. This is not a typo or an error. Also, Judge Siebert will need to get this motion ASAP as the October trial date had to be vacated due to this motion. Sincerely, Nathaniel Smith, father and protector of Carter Nathaniel Smith, president of Fatherly Freedom Incorporated, Nate at fatherlyfreedom.com with my phone number. Okay. So I had to include that letter to send this back. So this right here is this was my motion, motion to vacate the void EPO and any actions after that for violations of constitutional protections. I put plaintiff, District Attorney of Tuolumne County, defendant Nathaniel Smith, the real protector of the people, because I am doing this to fight for our children because our kids are being trafficked in Tuolumne County for Title 4D. Here's my opening oath. I request the court take judicial notice of the fact that I am without counsel. I am not schooled in law and legal procedures, and I am not licensed to practice law. Therefore, my pleadings must be read and construed liberally. There's the case law, reference it, Hines v. Kerner. Further, I believe this court has a responsibility and legal duty to protect all my sons and my constitutional statutory rights. United States v. Lee, 1882. I, Nathaniel Smith, the loving father of Carter Nathaniel Smith, the statements I provide this petition are based on my personal knowledge and beliefs, and I hereby declare that they are true facts to the best of my understanding. I, Nathaniel Smith, hereby submit this motion to vacate the EPO granted for a constitutionally protected activity issued against me on and in the above referenced case. This motion is based on the following grounds. Constitutionally protected activity. Filming in public, particularly in public spaces such as sidewalks and outside public office buildings, is generally protected under the First Amendment. If you are not infringing on other laws such as obstructing justice or trespassing, here are some key cases to address the legality of filming in public and the expectation of privacy. So I put filming in public. This case involves private citizens who recorded police officers arresting another individual in a public park. The First Circuit Court of Appeals held that the First Amendment protects the right to record public officials in the discharge of their duty in public space. This case is often cited as to support the right to film in public areas. Smith v. City of Cumming. The 11th Circuit recognized a First Amendment right to record matters of public interest, including activities of police officers. The court stated that individuals have a right to gather information about what public officials do on public property. Fordyce v. City of Seattle. Ninth Circuit recognized the right to film matters of public interest, including demonstrations and public gatherings, as protected by the First Amendment. Now, it is public interest if I do discover that there is an attorney locally that is doing unethical, unconstitutional, and disgusting tactics to kidnap children from our community, from healthy parents, right? I think so. And that's Julie Sacco. Okay, no expectation of privacy in public. Katz v. United States. Well, this case primarily is about wiretapping. It establishes the principle that Fourth Amendment protects people, not places. The court noted that what a person knowingly exposes to the public, even in their own homes or office, is not subject to the Fourth Amendment protection. United States v. Knotts. The Supreme Court held that a person traveling in a car on public roads has no reasonable expectation of privacy in their movements from one place to another, as they are voluntarily exposing those movements to public. She tried to say I was following her in her car, which I wasn't, but that case law shows that even if I was, it would be legal. California v. Carolina. In this case, the Supreme Court held that aerial observation of a fenced-in backyard from public airspace did not violate the Fourth Amendment, as there was no reasonable expectation of privacy from such observations. So an airplane was flying over and observing in a fenced-in backyard, and it's legal. These cases collectively highlight the legal principle that activities conducted in public spaces, such as filming, are generally protected under the First Amendment. In public areas, there are typically no reasonable expectation of privacy. And alleged contempt charges stem from violations of a temporary restraining order that should not have been legally enforceable. The emergency protection order was improperly granted as it pertains to activities protected under the First Amendment of the United States Constitution, including peacefully filming in public for media purposes. According to Tuolumne County Superior Court's website, see attached, constitutionally protected activities cannot be considered within the course of conduct in civil harassment cases. The issuance of the restraining order and the subsequent contempt charges infringe upon constitutional rights related to free speech and expression. Supporting case law such as Smith v. Sylvie, 1976, underscores the importance of protecting First Amendment rights from overbroad restraining orders. Bam! Now, Kevin Siebert denied this motion, even though it's spelled out to him, because he has a problem with comprehension and he's stupid. That's why. Long extended TRO and failed to disclose discovery makes the judgments void. Addressing the issues of extending a temporary restraining order, TRO, beyond typical durations and the failure to provide discovery reflect due process violations. These cases show that such actions may render orders void. Extension of a TRO and due process. California Code of Civil Procedure 527. In California, a TRO is generally intended to be temporary, often lasting no more than 15 to 25 days until a hearing can be held. Extending a TRO for extended periods such as 8 months without a proper hearing is a due process violation. They extended mine for 8 fucking months. Fuentes D. Shevlin, 407, U.S., 1972. This case emphasizes the importance of due process and the right to a hearing before being deprived of a significant property interest. While it deals with property, the principle of due process applies broadly, including cases involving personal rights like restraining orders. Matthews v. Eldridge. This case provides a framework for determining whether procedural due process requires balance the private interest affected, the risk of an erroneous deprivation, and the government's interests. Failure to provide discovery. So the district attorney's office failed to provide discovery. They still have not provided me discovery. They're said, oh, you can come down and pick it up. No. It's not go down and pick it up. It's you have to serve it to me. So here it is. Failure to provide discovery. Brady v. Maryland. Although this case is about criminal law, Cassandra, criminal law, It establishes that the prosecution must disclose evidence favorable to the defendant. Failure to provide discovery can be seen as a violation of due process rights. And remarriage of Lemon, this case discusses the importance of discovery. It ensures a fair trial. While it is not directly about failure to provide discovery, it underscores the necessity of discovery for due process. Orders rendered void. In marriage of Flaherty. This case discusses circumstances under which a court order may be considered void, particularly if issued without jurisdiction or in violation of due process. Like kind of like an 8-month TRO. United States v. Throckmorton. Check this out. This is from 1878, guys. Although an older case, it discusses the concept of void judgments, particularly those obtained through fraud or without proper jurisdiction. Right? Bam. Fraud, which is Julie's middle name. Fraud, because she's a fraud. She's a bogus fucking fraud. I don't even think she's a real attorney because she doesn't have the knowledge to be an attorney. In Biel, this case holds that judgment or orders rendered without due process is void. These cases collectively support due process violations when a TRO is extended without proper hearing and when discovery is not provided. They also provide a basis that such violations can render court orders void. The issuance of a contempt order shows lack of fair procedure undermines the legitimacy of contempt proceedings, supporting case law Matthew v. Eldridge, which emphasizes the necessity of fair procedures to protect due process rights. I would like to bring to the court's attention that the District Attorney Office failed to disclose the discovery within the time frame required by California Penal Code 154.5. Although I agreed to receive the discovery electronically, the link sent to me via email contained no files or information as evidenced by the enclosed video documentation. Upon notifying Cassandra of this issue, she responded by stating that the office does not mail discovery and that I could pick it up for a fee 3 days after being informed of the broken links. It is the responsibility of the district attorney's office to provide the necessary evidence, not to send broken or blank links. The situation demonstrates prejudice and bias by undermining the defense through the withholding of discovery. I respectfully request that these retaliatory charges be dismissed immediately. Social media posts as a legal tactic. My actions are protected by the litigation privilege under California Civil Code Section 47B, which provides absolute immunity for communications made in judicial proceedings. The contempt charges improperly infringe upon this privilege. Supporting case law is Silbert v. Anderson, affirming the scope of litigation privilege in judicial proceedings. My post on social media about my case and trial was a legal tactic I used against Julie Sockeld, knowing that she was cyber stalking all my social media, just as she does with all other opposing parties, including illegally logging into their social media accounts, violating federal privacy laws. I have never been arrested until the abusive attack from the court and the judges, more so from Judge Beiersdorf, who my child's mother, Olivia Phillips, admitted made him dinner one night. Judging by the look on his face when she said it, it appears that dessert was on the menu. I'm sorry. Julie Sockeld, of her own free will, chose to come to my social media online accounts and snoop around on her own. Posting on social media is a free speech right, and anything posted there is not defined as a true threat is protected. If I was forced to set my social media to private, that would constitute a form of coercive control, which was what the court has been doing with our children. So it's no surprise that they would allow one of the court's own gang members, Julie Sockeld, to stalk my social media. She made an accusation on her EPO that I made threats on my social media toward her, which is false and fabricated, just like her submission of a false drug test to kidnap my son from me in FL 17431 on February 2nd, 2024. I'm in complete shock that the Tuolumne County Superior Court, being aware of this felony fraud to kidnap a child and still allow this behavior. I have added some more cases which I feel are relevant to demonstrate other examples that are the honorable courts above Tuolumne County have protected the laws you all swore to uphold and protect. Relevant case law and legal principles. Snyder v. Phelps. Although not specifically about social media, this Supreme Court case upheld the First Amendment rights of individuals to speak on matters of public concern, even if the speech is controversial or offensive. The principle of this case can be applied to protect speech about legal matters that are of public interest, kind of like an unscrupulous attorney kidnapping children from healthy parents. Garrison v. Louisiana, the Supreme Court held that criticism of public officials, including statements related to their official conduct, is protected by the First Amendment, motherfuckers. Do you understand that, judges? Dumbasses? This case supports the right to discuss legal proceedings involving public entities or officials, including stupid-ass judges like Kevin Siebert, dumb fuck. In remarriage of Cananati, while this case does not involve social media, it discusses the importance of free speech in context of family law and the limitations on restricting speech related to legal proceedings. O'Grady v. Superior Court. This case involves a blogger who published information, which is what I am, about an Apple product. The court held that the blogger was protected under California's Reporters Shield Law, which underscores the protection of speech related to newsworthy information applicable to online publications. Doe v. Gangland Productions. This case involved issues of privacy and consent. In the context of a documentary, while not directly about social media, it highlights considerations of privacy versus public interest in published content. You guys are full of shit. Tuolumne County, you guys don't even know what the Constitution is. You're full of fucking shit. First Amendment protections. The First Amendment protects my right to discuss your legal case publicly, including on social media, especially if the case involves matters of public concern. Retaliation and abuse of process. The contempt charges are retaliatory in nature, intended to punish me for exercising my legal right, including my right to safely conduct business, right to my fundamental 14th Amendment to the care, custody, and control of my natural child, right to address grievances, right to free speech, and right to not have government interference, etc. I have been dealing with Tuolumne County Superior Court that has been attacking innocent fathers' civil liberties by unlawful litigation abuse, unlawful kidnapping of my child, extortion of inflated child support amounts from a judge with personal relationships to the defendant's child's mother, denial of right to fair trial, and with refusal to follow proper 170.1 disqualification due process. The judges, the district attorney, witnesses, have a financial interest in this case with a pending 42 U.S.C. 1983 claim in district court for continued fundamental rights and laws violations from parties in this case. Such use of legal process constitutes an abuse of process. Supporting case law. Barquez v. Merchant Collection, which discusses misuse of legal procedures for ulterior purposes. That's Kevin Siebert. He's abusing his authority. And the federal court's going to come down on him, I promise you. Equal Protection Clause. I respectfully request that the court take notice of another instance of prejudice as demonstrated in case FL 17431. In this case, the opposing party's client, who is also the opposing party in my other case, was found guilty of 2 counts of contempt under section 278.5. Despite this, they were only fined $290. In stark contrast, I, Nathaniel Smith, was arrested in court by 8 officers following a frivolous hearing, which I believe was orchestrated as entrapment to lure me to the courthouse. This situation clearly illustrates a case of prejudice and bias retaliating against a father who had his child unlawfully taken on fraudulent evidence without my presence, a violation of due process. Please see attached evidence and similar case law to support the justification for a federal complaint. Right to access the courts. Griffin v. Illinois. The U.S. Supreme Court held that states must provide trial records to indigent defendants when needed for an appeal in criminal cases. This case is foundational in establishing that the government has an obligation to ensure access to the courts. Bounds v. Smith. The Supreme Court ruled that the Constitution requires that prisoners be provided with assistance or tools necessary to access the courts. This could be extended metaphorically to mean that just as prisoners must be given means to access the courts, legal materials, so must individuals be able to physically access the courthouse. Due Process Clause of the 14th Amendment. The Due Process Clause can be interpreted to include the right to be heard, which necessitates being able to travel to and attend court. Any laws or actions that unduly restrict a person's ability to travel to court could potentially be challenged as a violation of due process, which is what they did. Okay, you ready for this? It's going to get nastier. Americans with Disabilities Act. The ADA requires that public facilities, including courthouses, be accessible to individuals with disabilities. This federal law ensures that those with disabilities have the means to access public services, including courts, which indirectly supports the necessity of safe travel to these facilities. Now, Kevin Siebert tried to say I violated the restraining order because I crossed paths with Julie in the parking lot. That is not providing safe travel to the facility. Case law on obstruction of court access. You ready for this, motherfuckers? Christopher V. Harberry. This case discusses the right to access courts in terms of being free from impediments created by state actors. That's right, Kevin Siebert, you're a stupid state actor. While it focuses on the right to litigate without interference, it underscores the broader principle that access to the judicial process should be unimpeded, even by stupid-ass, kidnapping, disgusting attorneys that try to file frivolous civil restraining orders to impede my way of getting into the courthouse. You guys all fucked up. You guys are full of shit. Look what I put on the bottom of every page, too. Following the Constitution increases quality of life for everyone. International perspective. You ready for this? You ready to hear some complaints that are going to the UN? International perspectives. Article 14 of the International Covenant of the Civil and Political Rights, which the United States has ratified, guarantees the right to a fair and public hearing. This implies that the need for safe and unobstructed access to court facilities. So you guys in Tuolumne County are violating international laws, and I'm filing complaint with the United Nations as well. Time to vacate the order. Extensive case law has established that emergency protection order EPO and temporary restraining order TRO in question are void. I intend to present case law demonstrating that void orders can be challenged and vacated at any time in any court. Orders that are deemed void lack enforceability, and any alleged violations of such orders cannot be enforced. A void judgment is not entitled to the respect accorded a valid adjudication, but may be entirely disregarded or declared inoperative by the tribunal in which effect is sought to be given to it. It is attended by none of the consequences of a valid adjudication. It has no legal binding force or efficiency for any purpose or any place. It is not entitled to enforcement. All proceeds founded on a void judgment are themselves regarded as invalid. That's 30A, Juror Judgments, page 44 and 45. That's a judicial book. A judgment may not be rendered in violation of constitutional protections. A validity of a judgment may be affected by failure to give constitutionally required due process, notice, and an opportunity to be heard, right? Kind of like when you guys were having ex parte communication and submitted fraudulent fake drug test to kidnap my child, you piece of fucking garbage. The limitations inherent in the requirements of due process and equal protection of the law extends to judicial as well as political branches of government, so that a judgment may not be rendered in violation of those constitutional limitations or guarantees. I have a constitutional guarantee to due process. I have a fair, and I am not getting afforded a fair trial by a judge who is being sued for $100 million. You get that, Kevin Siebert? Or I should say, Tyrant Kevin. A void judgment does not create any binding obligation. Federal decisions addressing void state court judgments include a judgment which is void upon its face and which it requires only an inspection of the judgment roll to demonstrate its wants of vitality, and a dead limb upon a judicial tree which should be lopped off if the power to do so exists. People v. Green. If a court grants relief, which is under the circumstances it has any authority to grant, its judgment is to that extent void. An illegal order is forever void. You hear that? You hear that, Hallie Campbell? Hallie, you need to go read a goddamn book, Campbell. This is what you did. This is what you're doing to dads. Every time you make a judgment with a dad not present, even if he misses a court date, you take custody away. You're violating due process. You understand that, right? 14th Amendment right to the care, custody, and control of our children. Not that you have control, care, custody, and control. We do, not you. I think you're mistaken. Either that or you're just dumb and you just don't know what the fuck you're doing. If a court grants relief, which under circumstances it doesn't have any authority to grant, its judgment is to that extent void. A void judgment is no judgment at all and is without legal effect. A court must vacate any judgment entered in excess of its jurisdiction. A void judgment does not create any binding obligation. Federal decisions addressing void state court judgments include. You guys understand that? You guys get that? You guys are violating constitutional rights and privileges, and you guys are full of shit. You need to you need to take your robe off and walk away from the bench, because your piddly little state authority doesn't subsede this. It does not subsede our Constitution, and you're going to find out the hard fucking way if you want to keep pushing this. An order that exceeds the jurisdiction of the court, which is you guys, is void or voidable and can be attacked in any proceeding in any court where the validity of the judgment comes into issue. Conclusion. Considering the foregoing reasons, I respectfully request that this court vacate the void contempt orders issued against me, as well as the frivolous restraining order that Attorney Julie Sockeld has used to support her deceptive actions. These legal actions have unjustly exploited the court system to separate a child from his parent without any legitimate basis, state or federal constitutions. I further request any additional relief that the court deems just and proper. Should this motion be denied, I respectfully seek to file a motion for a disqualification under Section 170.1, as this court has demonstrated prejudice and bias in this matter. My commitment to this cause will persist until Carter Smith is reunited with his father. The parties involved in this federal kidnapping lack the authority granted by the United States Constitution, the federal Supreme Court, the Federal Court of Appeals, the California Constitution, or any applicable laws or codes. This indicates that the orders in question were issued without proper jurisdiction, thereby conflicting with the United States Constitution, the California Constitution, and Supreme Court rulings. This situation constitutes a breach of immunity, as actions were taken entirely outside of jurisdiction while simultaneously violating my absolute immunity under California Civil Code 47B. And it is also important to note that when Judge Kevin Siebert ordered that I may only contact Julie Sockeld in a family law case, it obstructed my ability to serve papers regarding the district court case 124 CV 592 KES BAM, that this obstruction could potentially violate federal laws, including 18 U.S.C. 1501, 1502, and 371. Then I added this. I always add little footnotes in there. It says, the several states have no greater power to restrain individual freedoms protected by the First Amendment than does Congress of the United States, Wallace v. Jeffrey. The First Amendment has been found to include the right to religion, the right to raise one's children and one see fit, loss of First Amendment freedoms for even minimal periods of time unquestionably constitute irreparable injury. Though First Amendment rights are not absolute, they may be curtailed only by interests of vital importance, the burden of proving which rests on their government. Elrod v. Burns. Then I put my signature at the end, dated September 21st, 2024. I also put in a declaration of facts or affidavit. This is basically a rundown of everything I've dealt with. Here's some of the categories involved. I have oath I swear, establishing fundamental father's rights, litigation abuse by attorneys in the court, constitutional concerns in Tuolumne County, and judicial overreach and Title IV defraud, legal battles and self-education. Here's a section in here I'm going to go ahead and read. But the legal battles extended over a year and a half, with each court appearance compounding the injustices. Feeling failed by the legal representation available, I embarked on a self-directed study of family law, eventually branching into civil rights and constitutional law. Utilizing my experience in AI technology, I created a virtual mentorship program to enhance my legal education. This journey transformed my understanding and approach, helping me represent myself in court effectively. Despite presenting clear evidence challenging the validity of the restraining order, including a flawed drug test accusation debunked by medical reports, my efforts to restore justice were continually thwarted in favor of lying attorneys and biased judges. Here's the case law. Dubert v. Merrill Doe Pharmaceuticals. Although primarily applicable to federal courts, this case establishes standards for the admissibility of expert testimony, scientific evidence, emphasizing the need for reliability and relevance, which can be analogously applied to argue against flawed evidence. Ongoing bias and procedural irregularities. And then I have a conclusion. I have side notes. Constitutional law that all government actors swore to uphold. Here's some amendments. There's my signature at the end. And I have the sections, civil restraining orders, ex parte, showing pattern of false allegations. Right? Here's her emergency protection order. Sokeld stated that Smith has been following her to her work and filming her and her vehicle. Okay, first of all, I did it one time, and it was from a public sidewalk. I did not follow her to work. I was already down there and decided to film something for a documentary I was putting together. And here's the thing. He put Lee, but he meant to put me, is also posting what Sokeld believes are threats on Facebook and TikTok. This was posted on December 15th of 2023, last year, right? I've never been charged with threats on TikTok or Facebook. So that's a lie. And me following her around, we already went over that. Case law states that I can follow her around in her vehicle if I want and film her vehicle. I can film her in public. What you can see in public, you can film. We've already discovered that that's a First Amendment right. So this restraining order is invalid. I have constitutional protections that this violated. So this sergeant right here, Nygaard, he's a moron. You're an idiot. This is constitutional. Why don't you follow your oath, stupid? And then Beiersdorf is the one right here. He signed off on this. Follow your oath, stupid. How about that? Why don't you follow your oath and quit being a dumbass? Okay. So we're going to go the law of void judgments and decisions, Supreme Court decisions on void orders. Here is Supreme Court rulings, which is case law that you state little piddly courts have to follow because these are higher courts that made these decisions. Void judgment does not create any binding obligation. Federal decisions addressing void state court judgments include, right? So here's an order that exceeds its jurisdiction of the court is void, voidable, can be attacked in any proceeding in any court where the validity of the judgment comes into issue. Now, Siebert doesn't understand this because he doesn't have good comprehension. In fact, I think he's like half asleep when he's up there. Okay, so look at this. This is the Superior Court of California, County of Tuolumne. This is their definition of civil harassment, right? Which is what Julie's claiming. Okay, look at this section that's highlighted. Course of conduct is a pattern of conduct comprised of a series of acts over a period of time, however short, evidencing continuity of purpose, including following or stalking an individual, making harassing telephone calls to an individual, or sending harassing correspondence to an individual by any means, including but not limited to the use of public or private mail, interoffice mail, fax, or computer email. Ready for this? Constitutionally protected activity is not included within the meaning of course of conduct. Like filming in public is not considered a course of conduct. So under me filming in public, which is a constitutional right, that is not considered harassment. Okay, you guys got that? That's on Tuolumne County's website. Highway Patrol reporting false allegations. So Highway Patrol tried to accuse me of threatening or harming a public official with injury or death. That's why they keep showing up in my court hearings. Here's the police report. This never happened. This is a lie. They pre-made this because they tried to arrest me for something I didn't do. This goes to show right here, and I went into this. I explained all this, that they were basically trying to trump up false charges on me. This is why the California Highway Patrol is being sued. Specifically, those two officers that keep coming into my courtroom. You guys are being charged with acts of terrorism. So get ready, motherfuckers. And I'm going to articulate it perfectly. Okay, prejudice, discrimination, and due process violations, right? This goes into how Olivia Phillips, the disgusting mother that she is, basically kidnapped my child under false pretense. She lied. Here's the court minutes from December 12th. This shows here. I'm going to show you guys how pathetic Julie is. You ready for this? Okay, you guys try to say, "Oh, Nate's a pretend attorney." Okay, what does this say? The court does not believe that CCP 631.8 is appropriate for this hearing. So, okay, let me go back. Attorney Sokeld motions the court to CCP 631.8 for a judgment. The court takes a break, right, to research. Get this. I was self-represented, right? We're in trial. The court does not believe CCP 631.8 is appropriate for this hearing. PC 1118.1 is more appropriate for this oral motion. PC 118.1 is provided to parties. Attorney Sacco motions the court to dismiss pursuant to PC 1118.1. Discussion held. She got help from the judge. That's how shitty of an attorney she is. She got help from the judge because she didn't even know what motion to file because she's stupid. Motion to dismiss PC 8.1 is granted, right? So she got help from the judge. That's not allowed. That's showing favoritism, right? So that in itself, she should be charged with those other 2 contempts. But get this, after everything was all said and done, Olivia was still found guilty of 2 contempts. Petitioner provides argument regarding contempts 3 and 4 beginning at 11 a.m., ceasing at 11. So 1 minute. Took 1 minute to argue contempts 3 and 4. Attorney Sacco provides argument regarding contempts 3 and 4. She discussed it for a little bit longer. The court questions regarding holiday parties argument. The court finds the respondent guilty beyond a reasonable doubt as to contempts 3 and 4 and issues a fine of $220 for contempt 1 and a fine in the amount of $70 and contempt 2 for a total of $290. So she was fined $290. They're trying to throw me in jail for a year. For 3 contempts. She was charged with 2 contempts. She was fined $290. And I bet you, I'm going to get this certified. I bet you she didn't even pay that fine. I bet you. And the fact that she didn't pay that fine means that she got away scot-free. And this better be on her record. These are misdemeanor charges. Okay. So then get this. We go further down. So right here, Julie tried to claim that I was a Jehovah's Witness and that I shouldn't get my Christmas Eve visitation, which is another violation of the First Amendment because that's freedom of religion, right? The court confirms with parties that the petitioner has visitation on Christmas Eve till 6 p.m. Now, I was supposed to get him overnight. They took away my overnight Christmas Eve, which I get every year, because the claim that I was a Jehovah's Witness. They just violated my religion, even though that isn't even my religion. It was a lie. It wasn't even true. And then look at, like, oh, this is just total. This is a fucking crock of shit. Here's the complaint on Julie that went to the California bar. I sent it directly to the Chief Trial Counsel. These are all the violations, parties involved. Check out this complaint. This is a fucking badass complaint. In the matter of the complaint against attorney Julie Sockeld with her fake fucking attorney number, right? Look at all this. In the formal complaint for ethical violations, fraud, and allowing perjury in Tuolumne County cases FL 17431, CV 65761, CRM 75348, CRM 75349. Parties involved: respondent Julie Sockeld, California State Bar number, and Olivia Phillips, because you're going to jail. I don't care. By the time this is done, you're going to be in prison. Because there are so many federal violations and you're just continuing it on. The longer you keep my kid, it's just making it worse. Allegations against respondent, legal violations. These are all the state law violations: perjury, aiding and abetting, fraud, obstruction of justice, false reports to law enforcement, child custody and support fraud. Federal laws: perjury, mail and wire fraud, aiding and abetting, obstruction of justice, conspiracy, civil rights violations. Additional allegations: collusion and judicial manipulation, violation of parental rights and due process, unjust arrest, failure to uphold ethical standards, relief requested, demand immediate investigation and disciplinary action, immediate suspension of Ms. Sockeld's license to practice law pending the outcome of an investigation, a thorough review of her involvement in cases listed above, disbarment if found Ms. Sockeld knowingly participated in allowing her client to commit perjury and fraud, which that's a slam dunk. Referral to the California Attorney General's office for potential criminal charges. Summary: Ms. Sockeld's actions have caused irreparable harm, complainant's relationship with his son, and have undermined the integrity of the legal system in Tuolumne County. The complainant trusts that California State Bar will take swift and decisive action to hold her accountable. Complainant expects to be informed of the status of this complaint and any actions taken against Ms. Sockeld should the State Bar act. Complainant will escalate this matter to the federal authorities and pursue further legal remedies under 42 USC 1983. Here's the attachments: personal declaration of facts, full reply to perjury on the court, right? This is proof with the medical records that they committed perjury. So respectfully submitted. Then I added, here's a brief list, and I added this to the complaint. Brief list of alleged criminal charges against Julie Sockold and Olivia Phillips. United States federal laws, perjury, 18 U.S.C. 1621, federal law, penalty up to 5 years in federal prison. Fraud, 18 U.S.C. 1341, mail fraud, and 18 U.S.C. 1343, wire fraud, up to 20 years in federal prison, 30 years if it affects financial institutions or fines. Aiding and abetting, 18 U.S.C. 2, penalty, same penalties as the principal offender. Obstruction of justice, 18 U.S.C. 1503, penalties up to 10 years in federal prison. Conspiracy, 18 U.S.C. 371, up to 5 years in federal prison. Civil rights violation, 42 U.S.C. 1983, penalties, civil remedies, including monetary damages, injunctions, and attorney fees. Racketeering, RICO, 18 U.S.C. 1961 to 1968, penalties up to 20 years in federal prison or civil penalties. California state law, perjury, 2 to 4 years state prison or fines. Fraud, California Penal Code 484, penalty. Depending on the amount of money involved, fraud can be charged as a misdemeanor or felony, with penalties ranging up to 1 year in county or up to 3 years in state prison. We're gonna calculate how much child support you took from me fraudulently. Aiding and abetting, California Penal Code 31, penalty, the same penalties as the principal offender. If the principal is convicted of perjury or fraud, the aider or abetter faces the same penalty. That's for you and Olivia, right? Both people. Obstruction of justice. Actually, you know what? This is going to apply to Cassandra too, because she didn't charge it. She ignored it. She swept it under the rug. So that's aiding and abetting. Obstruction of justice, California Penal Code 148, up to 1 year county jail. False reports to law enforcement, Penal Code 148.5, up to 6 months in county jail. Harassment, Civil Code 527.6, penalties, civil penalties, including restraining orders, fines, and possible jail time. Child custody and support fraud, Family Code 3020, civil penalties, including modification of custody, orders, fines, and possible criminal charges if fraud is proven. I'm going to prove that fraud. You're fucked. You ready for international and human rights violations? Universal Declaration of Human Rights, Article 7, equality before law. Everyone has a right to be treated equally before law and to be protected from discrimination. You guys violated that. Article 8, right to an effective remedy. Everyone has a right to an effective remedy by the competent national tribunals for acts of violating fundamental rights, which you guys did. Article 10, right to a fair trial. Everyone is entitled to the right to a fair public hearing by an independent and impartial tribunal. You violated that, Kevin Siebert. You violated international laws. International Covenant on the Civil and Political Rights. You should have reviewed this, Mr. Siebert, but I know your comprehension's a little affected, but you should probably have somebody read this to you. Article 14, right to a fair trial. This article guarantees a right to a fair and public hearing by a competent, independent, and impartial tribunal, right? That's the International Covenant on Civil and Political Rights, the ICCPR. You violated that, which the state, California, has signed into. Convention on Rights of a Child, Article 9, right to the child to maintain contact with both parents. This article emphasizes that children should not be separated from their parents unless it is in their best interest. Bam! You violated the covenant on the civil right. You violated the CRC. So that's the end of that. That's what I submitted to the courts. That is what Kevin Siebert denied. And he obviously didn't read it, and he probably should have before he denied it, because it really made him look bad. It made him look like an incompetent judge, because there's no way any other judge would deny that if they read that. That is a fucking slam dunk. And the fact that Cassandra did not agree with that shows she is not looking out for the best interests of the people. She's not representing the people. She's actually, she's out here to do a witch hunt. She's out here to incriminate as many people as she can, and she needs to go. She needs to go. She's be gone. She'd be thrown in jail. Eric Hovatter, I'm going after him too. He's got a lawsuit coming his way because of this. I'm going to take everything he's got. He's done. So, yeah, I need you guys to support me, man. Like, I'm sitting here fighting our community. I'm fighting Tuolumne County by myself, and you guys are sitting back here being all chicken shit. Stand up and stand your ground. Stop letting Tuolumne County fucking traffic your children.